thank you so much for coming. And I fear that after that, what I have to say will be something of an anticlimax. Because this was a cyberspace talk, I decided I wanted to talk about content moderation. And one motivation for this talk is to tell you some war stories. I was a co-founder of a nonprofit, the Organization for Transformative Works, or OTW, which is focused on protecting and preserving non-commercial transformative works, specifically fan fiction and other fan works. That is, new stories and art based on existing, often in copyright works, such as the Harry Potter series and the Avengers movies. In the past, nonprofit archives had existed for specific fandoms. The OTW wanted to create a multi-fandom archive and to protect its continued existence with a legal existence and structure that would be separate from the individual situation of any given archive maintainer. So we went to the 501c3 nonprofit form. So we did. Our all-volunteer team includes the largest majority female open source coding project on the web as far as we are aware. We created software that allows fan creators to post their works and tag them so they can reach the right audiences. Our terms of service are not influenced by advertisers. Our mission is to host almost everything within non-commercial fandom that we legally can, even if that content is, as we say, controversial, offensive, or badly spelled. And the result is we have over 2 million works, over 770,000 registered users, over 115 million page views per week, which puts us in the top 50 websites in the US, according to Alexa's statistics. Turns out, though, that although most fans are lovely people, some of them do really bad things. Fans are, first and foremost, people, and people occasionally do very bad things. So our success has not come without costs. Our all-volunteer content and abuse team faces some serious challenges. Not only do people sometimes abuse our platform to engage in harassment or spamming other users, but also people abuse our content moderation system as a means of harassment. If you'd asked me 10 years ago, I would have been skeptical that a person would pretend to be another person's parent in order to get their account closed, or pretend to be a police officer, or pretend to be a lawyer acting on behalf of a copyright owner. I no longer need to believe in these things because I've seen them. And according to Eugene Volokh, who has researched these things extensively, fake court orders to get content removed from places like Google that will only do it if you have a court order are popping up in other contexts, such as when someone wants to silence a blogger on Medium or remove negative content from search results so it'll be unfindable. So we, as intermediaries, are experiencing our own version of fake news, and that's one of the challenges we have to face. In addition, although at the OTW we believe strongly in fair use, we've also encountered situations where our users' freely available works have been copied wholesale and then sold on platforms like Amazon's in violation of their own copyright interests. We've tried to help them through that, help them through the takedown process. We've also encountered cases where we've had to act against confusing uses of our trademarks. We've even had a typo squatter register our domain name plus one letter and then mimic our interface, encouraging people to input their login credentials. So classic phishing, although advertising revenue seems to have been the primary goal. We've had problems with apps on the Google and Apple app stores using our name and our logo. At which point we receive complaints from frustrated users who say, I paid for this. Why isn't it working? Of course, we are free and want to stay free for everyone. And we are also ad-free. So we've experienced rights holders' frustration with intermediaries that don't seem to care about your problems until you spend a lot of money on some formal process, whether that's the UDRP, the Uniform Domain Name Dispute Resolution process for domain names, or a potential lawsuit if there are other issues. So as the song says, I've seen the world from both sides now. We've sent C&D letters, we've received them, and I'd say the legal process in general has worked very well for us. But that's in substantial part because we are extremely lucky to have a highly qualified group of volunteer lawyers. Most sites, even commercial sites our size, won't have 4 or 5 experienced lawyers on call at any hour of the day. By the same token, we do rely on volunteers. We can't hire 10,000 people to moderate content. We have an annual budget that's lucky to crack $200,000, most of which goes to keeping the site up. We can't even hire 10 people. We can't even hire one person yet. I hope someday that we'll be able to do that. We rely on this small, hardworking, long-suffering team of volunteers to recognize, to investigate and identify abuse, and they're doing their best, but they'll never be able to catch everything, and they have to go through a lot to do it. We don't have some of the problems that other sites have in terms of incredibly awful content, but they still see some stuff that I think they wish they hadn't seen. So today I want to talk about this presence of bad content in the online ecosystem. There are really three major categories, it seemed to me, that have excited the most attention in the legal system. So there's copyright owners who decry massive amounts of copyright infringement. Then there are harassing types of conduct. A lot of the focused legal attention has gone to revenge porn, mostly used to humiliate and blackmail women. And then there's the general problem, which we're just starting to grapple with, I think, is fake news, political attempts to pollute the system. And like many other people, I am asking, what is to be done? What can we do? So there are people who argue for increased government intervention in the form of legal duties on intermediaries to remove various types of unwanted content. In the US, this has been met with a lot of resistance, including on a First Amendment basis, and also an argument that a better solution would be to reconstruct some sort of democratic process within a service itself, within the service's polity, as it were. Thus trying to get us to a procedural solution to knotty problems of substance. What is harassment? Where do you draw the line? I want to complicate the debate here by discussing the multiple types of actors that exist in the intermediary space itself. Some of them don't intersect with ordinary users, but they're being recruited into policing content. Other entities, like the OTW, don't resemble the profit-seeking, ad-supported entities at which most regulatory and governance proposals are directed. So if your proposal assumes that we will use our ad revenue to do something, it's not going to work for us. If we don't keep these variances in mind, we're unlikely to get the results that we seek. I'm going to start with intellectual property issues, because that's where I started my career and my work at OTW. One thing that non-specialists are rarely aware of is the extensive regulation of domain names done by the Internet Consortium for Assigned Names and Numbers, or ICANN, and the providers to which it has delegated authority to administer various top-level domains like .com, .uk, or newer entrants like .bike and .london. So in 1999, trademark owners succeeded in procuring something called the UDRP. This is mandatory arbitration for trademark claims that are based on allegedly infringing domain names. You can look at the content of the domain to figure out whether there's a violation, but the domain name itself has to be identical or confusingly similar to the trademark owner's trademark before the UDRP kicks in. So trademark owners secured this extra protection, which no other category of individual objections to domain names has, by virtue of their persistence, not to mention, in fairness, some quite decent arguments in the multi-stakeholder consensus-based process through which ICANN operates. So ICANN is not a government, and it's not a democracy, but what it is a little hard to define, which is why its role in the intellectual property ecosystem is still apparently up for grabs. So if you tried to register Coca-Cola.com, it's extremely likely the real Coca-Cola company would prevail in arbitration, which is generally faster and cheaper than trademark litigation in the courts. Arbitration also offers the opportunity for some rules that are more favorable to trademark owners than US courts are. For example, holding that putting the name of a trademark in the domain name for an anti-trademark owner critical site is abusive, although there's no consensus on these issues. And in fact, in the UDRP, there's no system of precedent. So you can cite previous decisions, but the arbitrator doesn't have to pay any attention if they don't want to. And so some people think this is a problem. Then ICANN introduced a large number of new global top-level domains, .london and .bike and hundreds of others. In order for trademark owners to accede to this expansion, because of course this is done by consensus, so if there's a large minority that's objecting, nothing tends to happen. So they said this will expand the number of domain names that could use our marks and will create a new policing problem for us. Trademark owners secured something called the URS, the Uniform Rapid Suspension Process, which is supposed to be faster and cheaper than the UDRP. It's for no-brainer cases of infringing use. Harder cases should go to the UDRP or to the courts. It's now been in place for several years with over 700 decided proceedings. How is it doing? That's a really good question. We don't know. ICANN is running a review process in which I am participating. Turns out trademark owners don't actually want to review the cases to figure out what happened in them because they're concerned that the results might be bad. My sense is actually that the results will indicate that the system is working pretty well, but it is notable that this is something they don't even want to collect data on. So, as I said, I have an interest in ensuring that trademark owners have some recourse against infringement too, although I think I'm perceived as entirely anti-trademark owner. The broader point is that rights owners don't stop when they lose a public battle. Big trademark owners, like big copyright owners, can afford to be persistent, and they often believe they can't afford not to be. As a result, when they don't get remedies in national law, they often try to get something, some new protection through an international treaty, or in this case, through private policy making at the choke points of internet connectivity. The domain name system sits up on top of the number system, so technically you don't necessarily need a domain name, but still getting rid of one or suspending one will cause huge disruption and make it very hard for people to find you. So the entities administering the system, domain name registries and registrars, don't have much skin in the game for any individual domain name. They may not fully take into account individual domain name registrants' interest in what's going on. So, for example, some registries and registrars are now selling extra services to trademark owners to allow them to block any registrations that include their names, regardless of whether the use would be allowed by the URS, the UDRP, or substantive trademark law. So Apple, if it pays, can block apple.farm for an apple farm if .farm is operated by one of these registries. What looked like a carefully negotiated balance between user and free speech interests versus trademark owner interests that was supposed to result from the ICANN process and policy has been replaced by these private mechanisms, similar to the way that Content ID has replaced copyright and fair use analysis on YouTube. This is the future of content moderation, if content moderation does not become a public policy issue. And it's not just trademark owners, who at least have a pretty clear relationship to domain names, who want to use the domain name system to shut down allegedly bad actors. So copyright owners are now trying to get in on the game. They are arguing that registries should, and maybe must, under ICANN rules, shut down domain names where the underlying domain, or the website, is used to infringe copyright. Not in the name, but in the content of the website. Anne-Marie Bridey has done some important work in this area, documenting what people are willing to admit on the record about these new policies, which are mostly secret. Copyright owners claim that they're going after only sites that are purely devoted to infringement. But without public guidelines and other transparency mechanisms, we just have to take their word for it. Copyright owners are also sometimes arguing that actual US law isn't good enough to protect their interests. After the failure of SOPA and PIPA, which were going to expand intermediary liability for copyright and trademark infringement substantially, but were fought back due to a large public outcry, big copyright owners are touting their policy preferences in subtler ways. So there are these private agreements with online platforms, and also they are arguing still that the current notice and takedown system for online copyright infringement in the US is broken. They argue instead for mandatory filtering of all content, which has been, I have to admit, brilliantly renamed notice and stay down to replace notice and take down. And here we do have some good and empirical work about what's actually going on. So Jennifer Urban, Joe Karganis, and Brianna Schofield have done some really important work on how copyright notice and takedown is functioning for US entities. What struck me most about their results actually was how well they corresponded to the OTW's experience, even though we weren't part of their research with intermediaries. What they found was that there are several distinct models of copyright takedown notice, copyright takedown process, excuse me. The vast majority of services, like the OTW, seem to be what they call DMCA classic. We receive relatively few notices of claimed infringement, so from dozens to hundreds a year in the services they talk to. Few of them are sent by automated services, and we subject them to individual review for validity. We reject notices that ignore free speech and fair use, or that are clearly trying to use the DMCA process to achieve non-copyright aims. Usually, actually, it's somebody who's trying to claim that their title is protected by trademark law. That's, in some sense, that's the modal DMCA notice we receive, for whatever reason. We remove anything that's correctly identified as infringement. But in essence, our process is artisanal rather than mass market. And we couldn't continue to do it if we start to receive a flood of automated notices. The non-DMCA classic models are adopted by the relatively few services that do receive a large volume of automated notices. They've responded, in general, by automating their takedown in return, and sometimes also by going further than the DMCA requires, sometimes implementing certain types of filtering, sometimes cutting deals with content owners to monetize user uploads of content claimed by someone else. There are plenty of problems with the content ID model, especially as it affects small copyright owners, in fact, but that's not my focus here. The point that I want to make in this discussion is that a requirement of filtering for intermediaries that host user-generated content in general, as the European community is trying to impose on intermediaries, is mistargeted. It takes a solution that has benefits for a few big copyright owners and big internet services and demands its imposition on other intermediaries. In fact, the EC is telling intermediaries, cut a deal with copyright owners. They're not going to, police the deal. Just, come to a deal or stop. And that obviously has some problems with monopoly power and the potential for competition and the potential for new services entering the market. And also, most of these other intermediaries are DMCA classic. Like us, they don't have big infringement problems in the first place. So the filtering and deal cutting is actually not the best solution for people who don't have big infringement problems in the first place. And many of us couldn't continue to operate if we had to bear the costs of developing and constantly updating a filtering system. It's not a matter of size either. So some very big sites like ours, like Wikipedia and Medium, the blogging site, we're all, WordPress too, we're all DMCA classic sites. We receive relatively few copyright claims, and of those, a relatively large proportion are invalid. Interestingly, a fact I found out at the recent Copyright Office hearings about notice and takedown is that this is even true of Amazon's Kindle Worlds program. So this allows people to self-publish various things. It turns out to be a DMCA classic environment. Amazon disclosed that a substantial number of the takedown requests they get for that service in particular are competitors who are trying to take another person's similar book off the market. This isn't to say that DMCA classic sites are the only ones who experience problems with the way the current system is constituted. Urban and her co-authors explained that nearly every service provider recounted stories of deliberate gaming of the DMCA system, including to harass competitors, to resolve personal disputes, to silence critics, or to threaten the service provider or damage its relationship with its users. The proportion varied by who it was, but they also all identified cases where someone had ignored fair use or targeted clearly non-infringing material. We also know that attempts to impose more obligations, even on those who can bear them, are likely to fail. It turns out users who are dedicated to piracy are really good at finding ways to root around obstacles. On the other hand, ordinary good faith users are more likely to accidentally get caught in traps. So the dynamic here is that each failed measure is likely to lead to demands for ever more restrictive actions. It's the drug war, except online, suppressing more and more legitimate speech in the process, if only by driving websites with fewer resources out of business. After all this, I basically ended up in the position that the DMCA's notice and takedown system, like democracy, might be the worst possible system, except for all the others that have been tried. Which leads me to my next topic, which is content moderation for even fuzzier instances of wrongdoing, like false news and harassment. As with so many other things, Jack Balkin at Yale got there first. He has proposed that a good way to think about the really important intermediaries of our time, and specifically he's talking about Google and Facebook, to a certain extent Twitter, but really it would actually do us some good to admit that we're talking about specific intermediaries. So he argues that many of the dominant online players should be treated as what he calls information fiduciaries toward their end users. So the idea would be that they have a duty to exercise, to engage in non-manipulation, so not try and convince them to vote by deliberately manipulating their feeds, or convince them to be happy or sad by deliberately manipulating their feeds. And otherwise, they have to act in good faith, as a fiduciary would, specifically with respect to the information provided to their users. And he points out that there's a kind of I don't know if seesaw is the right word. There's a dynamic here where there's pressure in some sense from below and from above. So private governance is now where most content decisions are being made, even in autocratic governments that don't have a First Amendment. When that is the case, both individual users and nation states are going to be putting pressure on the private intermediary. So they'll try and co-opt companies. Nation states will try and co-opt them into enforcing whatever their regulations are. So France regulates hate speech in certain ways, so it will make Facebook do that. Also, Europe will try and get Google to implement the right to be forgotten and tell Google, you have the obligation to make decisions about this. So, and if you get it wrong, you get a fine. Conversely, end users from the bottom up are demanding procedural guarantees. They want due process, they want transparency, they want like cases to be treated alike, even when it's Facebook, and it doesn't have the government's duty to treat like cases alike. One thing that I find perhaps ironic, perhaps it's just a paradox, is that proposals like this for regulation or for imposing new duties tend to lock in the idea that large online spaces where people engage with one another will be privatized and profit-seeking, and thus will have the cash on hand to build the tools that the regulators think are likely to diminish whatever harms they're concerned about. This has significant negative consequences, though, not just for startups, who can't necessarily comply with complex regulatory schemes, but also for people like the OTW, non-government, non-profit actors who don't want to build something advertising-driven. And the OTW is small, is relatively small. Wikipedia is the big example here. Recently, Kate Klonick, who's about to start teaching at St. John's, wrote a fascinating paper exploring how speech regulation had evolved at major social media companies, including Twitter, Facebook, and Google. Specifically, she looked at YouTube. And she found a bunch of interesting things. First, being advertising-driven does matter. So pressure from advertisers led Google to crack down on pro-terrorism speech on YouTube. And you've seen this recently with some other things like the fake news with respect to the Parkland shootings. They don't like bad PR, and they will try and get rid of stuff that the algorithm surfaces when it's offensive enough. Klonick also argues that platforms are economically responsive to the expectations and norms of their users. So they take down content their users don't want to see, but also keep up as much content as possible because it was posted by some user. So there's obviously some user, at least, who wants it up. And this leads them, for example, to push back against certain government requests for takedowns. But I think Klonick equivocates a little bit about who the relevant users are. After all, if you're not paying for a service, you're the product. And content that advertisers or large copyright owners don't want to see may be far more vulnerable than content that individual participants don't want to see. I think of what's happening in these governance structures as a variant of ontogeny recapitulating phylogeny. So as online services become more like total institutions, places where we live most of our lives, we want them to behave more like governments or branches of governments. Turns out Facebook's policy team has a bi-weekly meeting in which different teams from across the company, engineering, legal, content reviewers, external partners like nonprofit groups that advise them, they all provide recommendations to the team for things that will be written into the policy book. And the team leader tellingly called this meeting a mini legislative session. And Klonick found that Facebook isn't unique. Everyone's policies have some similarities to known legal systems with a detailed list of rules, trained human decision-making to apply the rules, and reliance on external influence to update and amend these rules. And the rules are usually similar for users inside and outside the US. So regardless of what the underlying state structure is, it turns out they invent the same thing. It turns out that speech regulations pose standard issues of definition. So defamation and hate speech are endlessly flexible. Even intellectual property infringements are pretty flexible. Standard problems of enforcement, who will catch the violators, and standard problems of equity or fairness, who will watch the watchmen. And these are far more than trivial details. Worse, as we've seen here and in other countries, governments quickly learn how to use and misuse platform mechanisms for their own benefit. The extent to which an abuse team can be manipulated is actually a separate challenge for content policy teams. And some of these techniques are going to resist handling even if they are identified. When government-backed teams overwhelm social media with trivialities in order to distract from a potentially important political event, which is apparently how the system works in China, it's very hard to imagine policies and algorithms identifying the pattern, much less sorting the wheat from the chaff. It is true, if we just said, okay, you have a duty as an information fiduciary to try, we could say that, and we might do a little better. We would be saying you have an obligation to protect users against epistemic fraud, fraud that affects their ways of knowing the world. But here's a question that puzzles me. If these are truly governance structures, if this is legislation, why would we as citizens of a democracy accept anything other than democracy itself, either representative or otherwise, in the regulation of these spaces? One consequence, of course, in the US of treating Facebook like a government would be that it couldn't regulate much speech at all and would almost certainly turn into a hateful cesspool. More hateful than it is now. So I'm just going to float a couple of ideas, and feel free to tell me how wrong I am. Perhaps some of us are more willing to accept interventionist models of content moderation because institutions like Facebook and Google are more like schools than like full governments. They are institutions that have near total effects on some people some of the time, some people almost all the time, but that still leave a broader world outside for people to have significant interactions with that broader world. So schools shouldn't be prisons, but they also needn't be representative democracies to be a part of a representative democratic polity, as long as they have sufficient connection to the overall polity. So policies in school are, in the end, influenced by area experts and by the people's elected representatives. There's still a lot of devil in the details, but the general idea that democracy requires oversight but not voting on particular acts, it may be persuasive. Or here's an alternative model if you don't like the school. What if platforms were run the way public libraries are run? Libraries are actually sharing economies. In the US, they've resisted other levels of government trying to recruit them into surveillance. They've resisted content filtering as a matter of mission, but they also struggle very hard to keep it an open and welcoming space for everybody to come in. So they have spaces for children, and if you do certain things in the library, they will ask you to leave. The fact that we are now in what James Grimmelman describes as a broken world, where virality means that there will always be some new outrage. And in fact, the algorithms invite its preparation. So he talks about the fact that people watch something that counts as popular, even if you're hate watching it. The analogy is to car crashes. So everyone slows down to look at the car crash. An algorithm designed to maximize engagement interprets that as a desire for more car crashes and produces them. This is not a great idea, but it's where we are. So there's always going to be something new, shocking, some new violation of the rules or violation of norms that requires a new rule that we didn't know we needed until it happened. I think maybe the school model might help us there. Children are inventive in this way, and more than that, new children constantly appear at the school in need of socialization. So the school develops a set of rules for integrating children into the environment and, again, hopefully into citizenship. We generally think of the process of handling this ongoing chaos as a matter of training in rule sets and some outside supervision rather than individualized review. That being said, we also, as a practical matter, accept that there's going to be some really terrible teachers and some really unfair decisions, and we've decided to live with that. This is especially problematic if we are thinking in the context of cultivating good citizens rather than just good test scores. What we have decided that there isn't a better alternative in general. Here's another possibility, maybe a little more lawyer-friendly. We could say that intermediaries have to be somewhat transparent about their rules, and we could require there to be something like APA-style review. So rather than reviewing individual decisions, we'd look at Facebook's policies because Facebook has become structurally integral to democratic discourse. We'd have to balance this against concerns about what full transparency would do. So, of course, once you have full transparency, people can game the system by doing just enough that they don't trigger whatever the letter of the rule is. It also has possibilities for violating the privacy of either people who made a serious mistake and were justly reprimanded for it but don't really deserve to be condemned forever, or people who are victims of harassment and could be re-identified if we do full details of what happened. But there are things that we could do to try and improve the policy making through a model of some sort of participation. So platforms are often designed by groups that are much less diverse than their users. And this creates some problems for expectations. Facebook's real name policy is a classic example where Facebook was designed and implemented by people who have no problem getting government IDs and in general whose identities generally match their government IDs. When that isn't you, that can make Facebook a very dangerous place to be. So one possibility is we could require product design that incorporates the viewpoints of multiple users. this would mean that the community would be more involved in making the policy, even if the implementation of the policy is then left to the abuse team. James Grimmelman, who I mentioned before, is one of the smartest people I know, and he has put it this way: responsible content moderation is necessary, and responsible content moderation is impossibly hard. This, too, reminds me of nothing more than democracy is the worst form of government, except for all the others we've tried. And I think if there's a little bit of hope, it's that contradiction is, in fact, where democracies, if not algorithms, live. We try not to be overwhelmed by the paradox of tolerance. We don't get it right all the time, but it is in the trying that we achieve what it is that we think we are committed to, the ongoing experiment. And that's, I guess, what I have the most hope for with intermediaries, that we will have the flexibility to keep experimenting and maybe find some answers. So now I look forward to you telling me why I'm completely wrong. Okay.
We have a mic to get this on webcast, the question. So anyone who has a question, raise your hand and I can come and bring this to you.
I just like to ask in terms of like, we said, thank you very much for the speech, obviously, very inspiring. Regarding the Facebook, that's a little different, I felt like, from other social medias or communities, like, because precisely because the real ID kind of policy, they implement the kind of a consensus algorithm in terms of you have to find someone within the network you know to verify you. Is that am I correct in that sense?
I don't believe that's how the real ID. Usually, my understanding is that if you're challenged, you have to produce a piece of government ID.
Okay.
And Facebook has sometimes relaxed the kind of ID they'll accept. So, for example, if someone has transitioned, in their social life, and their school ID has their real name. Facebook will accept that, but of course that relies on being a university student in a place that will do that for you, which not everyone has access to. It's also Dana Boyd has this great study about how many American teens just use fake names on Facebook, but if you make it sound like a white person, you never get called out on it.
Yes. The second question is regarding you're saying that the algorithm usually kind of populated towards chaos and like bad news kind of. So there always can be chaos in the because people attract to such kind of content. On the other side of it, you also mentioned that the abuse teams or the management teams or the regulators can. Sometimes, like for example, in China, they will populate the website or information with kind of irrelevant information to distract from the real issues. So how do you think the balance should be?
Yeah, so I mean, it can happen that it's like a really cute puppy, right? That there is also a desire to see those things too. And the problem is that we have both algorithms that just don't care. Like they will try and maximize whatever it is people are looking at. Sometimes they'll be looking at the cute dog, and sometimes they'll be looking at Kim Kardashian's butt. And rarely, unfortunately, will they be looking at what's going on in the mayor's office. especially if you make it really easy for them to see all these other things. And then, so there's the algorithm part, but I think you're also talking about the deliberate manipulation part. So if someone has an agenda, and especially if the agenda is just disrupt, it turns out, they can throw everything out there, right? So the reported stuff on Russia is that they did all sorts of different political views. The whole point was to make the system seem not worth participating in. And that's much easier to do than to push a particular view.
Thanks so much. This has been really fascinating. Some of these calls for moderation and filtering have been sort of fairly constant, right? I think that's true of the calls coming from IP rights holders. Others seem to be sort of cyclical, right? They come and go. And I get the sense that right now we're in a period where it's maybe not the peak, but we're seeing a lot more of these calls than we have in recent years. So just today, I'll give you 3 examples, right? So just today I read articles about SESTA, about this porn filtering proposal in Rhode Island, right, where they're going to shut off all access to internet pornography unless you pay $20. This is like an actual legislative proposal. And there was also this letter from 5 senators to Google and other intermediaries asking them to filter out search results related to opioids. So my sense is we're seeing more of this now than we have for a while. So I guess 2 questions. One is, do you agree that that's empirically the case? And if so, what do you think is driving this sort of renewed interest in filtering and moderation?
So I want to specify, I think, do I think that if it exists, it's confined to the U.S.? I may think that, because the willingness to regulate has bopped along at a much higher level everywhere else, because of our uniquely free speech and commercial free speech protective environment. I think it's hard to say. I think the salience has gone up of these calls, and I think there is a more general sense that the news environment has been polluted in ways that impinge on people who weren't looking for that. Whereas a lot of the previous debates have more been about whether people looking for stuff should be able to find it. And American law is usually willing to answer yes, right? And so I think that may have increased the salience of these claims, but yeah, I guess that's as far as I can go. But
so thank you. This is not an area that I have virtually any familiarity with, so I'm fascinated and intrigued and interested in knowing more. Just last night, Jill Lepore, a historian from Harvard, was speaking in town, and she's written, it's coming out soon, this sort of vast history of America. And she has an incredible, expansive view, and I was reminded of it when the end of your talk turned to sort of the comparisons and the interrelationship of these issues to democracy. So you put me right back into her talk, and at the end, the questions were centered on sort of whether she has hope for the future since things have become so divisive, and then a question about educating students. And her number one suggestion about the younger generation was to encourage them to stay away from social media. And I was with my almost 18-year-old daughter, and I was trying to, and she was so impressed with her, and then this just dashed her to the ground. You know, she couldn't understand how you could think about getting rid of their primary method of communication. And so I was trying to give her another viewpoint on all of the information that's out there, and I'm interested in your perspective, and I know you're focused on sort of copyright and trademark violations, but the substantive content that is reflected in the term and the task of content moderation, how much would you say reflects kind of a monetary motivation versus the dark side of human nature and the more emotional, psychological desire to disrupt and do harm?
So honestly, I think that it's kind of a toxic intersection. That is, so we have two systems that are kind of lurching along. One is the algorithmic system. So the algorithmic system will surface anything that people like, right? Because then they run ads against it. That is indifferent to the content, as long as it keeps you coming back. And then we have people who deliberately inject into that things that they hope will get picked up, and their motives may well just be monetary too, right? So those are the Macedonian content farmers who did, you know, the anti-Hillary Clinton articles because they knew that those would be widely shared, and so they'd get paid a bunch of money. So they're just indifferent. You know, if it had been somebody else, it would have been something else. And then you have the people who actually, so there's the Washington Post story on the Reddit subreddit where people immediately after the Parkland shooting plotted to distribute false information about the shooter so as to pollute the narrative. And I don't think they were motivated by money. I think they were, in some moments, I try and think of them as people who are motivated by what they consider to be a larger truth that justifies smaller untruths. I still think that's corrupt and terrible, but I guess I have to tell myself that that's what they think. Otherwise, I would lose all hope.
I have a question about, so with the difference between content mediators where people have to actively seek out information versus content mediators where it's kind of curated for the user, is there, I mean, with the interplay of freedom of speech and you know, regulatory options, is there a difference there, and is there a difference in the willingness to regulate and also just in terms of like the legal ability to do so?
I think that's a great question, and doctrinally, seems to me the answer is simple. No, there's no difference as a matter of U.S. Speech doctrine, because both of those are going to reflect some judgments about how the user wants you to respond to the query. Now, the query may be very broad, like what's up on Facebook, right? Which is essentially the query you're sending Facebook when you load your page, right? What's going on? As opposed to the query you give to Google, which is Google, whatever it is I want to know, right? But both of those involve algorithms that almost certainly no human has touched in their deepest recesses. And you know, humans have tweaked perhaps for specific reasons that you will never know about. But it's still going to reflect judgment about what results are responsive to your request. So, and I'm not sure we could even do that in terms of practically distinguishing it. This is sort of why I say, like, let's just admit it. It's Google and Facebook. If you want to regulate Google, then fine, put Bing in. You know, then we should actually be regulating those. And this may be also where antitrust law has a greater role to play, because part of the problem here is that people are proposing, like, let's make platforms do X, when really, you know, they want Google to do something, or they want Facebook to do something, and that might be fine. I mean, probably not constitutional in the U.S., but other countries might be able to do it, but they shouldn't be doing it in the across-the-board way that they end up proposing.
I have a question kind of about moderation and content moderation in respect of the individual. And if you mentioned that people who want to do these things are very good at finding ways around anything we put in their way. So instead of trying to figure out more and more how to more regulate and enforce and restrict, wouldn't it be a better solution to put the content moderation on the individual and put it more on the individual to filter what they're viewing, and that way this will die off, or at least be segmented to a certain population that it's no longer an impact?
Yeah, so it's a nice hope. There are a couple of reasons it doesn't work, at least not for all circumstances. So first is the fake news problem, right? So if I have expressed an interest in political news, then I'm going to get that, and only some other form of intervention can help me avoid the stuff that I want to believe but is in fact fake. Then there's distributed harassment. So Twitter has tried exactly what you're talking about. The problem is it's not just the ease of making a new account. It's that there are some communities where you can get a group of people who will each sequentially show up and I apologize, call somebody a cunt who deserves to be raped, right? And the effect of that is cumulative, and you can't do it just by blocking if you want to participate in the system at all. You can do it by leaving, but that's kind of what they're trying to get you to do. So it works in some circumstances, and in fact, at the OTW, our content policy relies heavily on tagging. So we actually say, you're required to tag your works in certain ways, and we can actually impose some tags on you when we wouldn't take the content away. And then we do rely on people to, filter. But first, it's possible to abuse that too. And we get reports where people are sort of harassing each other by saying they don't have the right tags, right? So it is a good idea in many circumstances, but it doesn't reach the fact that the platform is a platform designed to send content to you one way or the other, and therefore it will have a structure no matter what. So the question is, what is that structure?
To follow up with that, do you think that it is possible in any real scenario to work out a balance between having the freedom that we all desire with the security? Because that is a common problem of increased security, decreased freedom, and the inverse. Yeah, so honestly, the only thing that might do that would be an unlikely large-scale devolution. That is, if we didn't have Facebook, right? If dominant platforms, if the largest platforms looked something like our 770,000 users, and maybe you had 5 different accounts, so there were 5 different communities that you're a big part of, but it would be different in different places. Then we might be able to develop the kind of community norms that sustain people in the long term. But, and this is what I think the sociologists call context collapse. Once you have Facebook, I think it's hard because you get people with completely different norms just colliding. And sometimes it's really that both of them think that they are in the space that allows whatever it is they're doing. Sometimes they're just trolls, but sometimes there's a legitimate disagreement about what this space is for. So there's a gentleman actually.
I just wondered if you could make more comments about the Russian plans or their operations in the recent elections.
So obviously I have no insider knowledge of this. What I think it reveals about what we want platforms to be doing is that algorithms can't compensate for all kinds of deliberate pollution, right? So, and in fact, they may be uniquely ill-suited to catching deliberate pollution because they're, it's not like cancer where, you train a machine to look at MRIs and it can learn to identify cancer better than an oncologist. The people doing the pollution are themselves responsive to what they see the moderators doing. So the only thing that we may need to be able to do is insert more humans in. And of course that has huge problems of its own. It's costly. It then infects whatever the humans are biased with. They'll be biased too. But it may take a thief to catch a thief, and not an algorithm.
No, I think on that, why would we once again thank Professor Tushnet. Reception outside following this.